Hi, everybody. My name is Carmen Noble. I'm going to wait for these numbers to catch up. It's exciting. And then we'll start in about 20 to 30 seconds. Okay, let's get started. Hello, everybody, and welcome to our webinar, How to Read a Court Docket, Tips for Finding Facts and Stories Amid the Arguments. I'm Carmen Noble. I'm the Program Director and Editor-in-Chief of the Journalist Resource at the Shorenstein Center. Before we begin, I'll mention a couple of quick things. One, this webinar is being recorded, and we will be posting the resulting video on the Shorenstein Center website, as well as on journalistresource.org. So you can share that with your friends. Two, we will have a brief Q&A at the end of the session. And if you have a question, please submit it in the Q&A box at the bottom of your Zoom screens. You're also welcome to use the chat to chat with each other via the chat box, but please try to keep the discussion on topic. And again, if you have questions, use the Q&A box rather than the chat box. And now I am happy to welcome our instructor. Eugenie Reich is a former journalist and current whistleblower lawyer. She served as a core member of the litigation team that achieved the largest yet recovery in a pharmaceutical fraud case pursued without government involvement. She attended law school after a 15-year career as an investigative science journalist and is the author of the 2009 book, Plastic Fantastic: How the Biggest Fraud in Physics Shook the Scientific World. She now has her own whistleblower law firm in Boston, Eugenie Reich Law, LLC, which specializes in fraud cases against evidence-based organizations that have gone astray. Eugenie, thank you for taking the time to share your knowledge today, and I'll hand it over to you.
Thank you. Thanks, Carmen. It's nice to meet everybody. I'm going to share my screen now because I have a presentation here. Okay, you should see my PowerPoint, and now I'm going to make it go to full screen. Carmen, can you nod that you see my first slide? Okay, good. So as Carmen said, I created a whistleblower law firm here in Boston, Massachusetts, 2 or 3 months ago now. And I became a lawyer after a career as an investigative science journalist. When I was in law school, so I went to law school after having my kids. I think people in the news industry might relate that I was sometimes told your resume is too long, too many different jobs. So now I made a very short one to introduce myself today. Basically 2 blocks. I was a science reporter, and then I was a whistleblower lawyer, and in between I was in law school. As a science reporter, one highlight was publishing a book in 2009 about a 2002 fraud case. And I think what's interesting is the book sort of had some attention when it came out, then died off. But then when it came to about the 20-year anniversary of the fraud I wrote about, so 2022, there was some interest in it again. And then as a whistleblower lawyer, my most notable thing to date has been being involved in the Biogen litigation, which was a whistleblower litigation. And I'll talk a little bit about that. I'm not going to talk about anything confidential in today's instruction. I will talk from the dockets, the court dockets that are public, and just try to talk about how you can use and follow a court docket, how using my perspective as a former reporter before, sort of what I wish I might have known then about how to read these public records that exist. So what is a court docket? It's basically a formal record of everything filed in a lawsuit. As we'll see, they're sometimes sealed and they're sometimes more commonly publicly available. Where can you find them? You can go to PACER, which is where you can find federal dockets, or you can go to the mass court system. I'm in Massachusetts. If you're in a different part of the country, you'll find it by searching your state and look for in Google for phrases like trial dockets or county dockets or something like that. And don't confuse the docket with the court calendar. The court calendars are telling you about hearings or status conferences and so on that might be coming up that day or that week. in any case. But then to know what's happened to date in the case, you would go look at the docket. So the docket is like a transect through time, or a record through time, and the calendar is what's happening on that day in the court system. One thing I'll highlight is that hearings are going to Zoom now more than before, because of the pandemic. After the pandemic, a lot of the sort of less significant events that are still of interest did not go back to being solely in person. So if you can inquire with clerks, and you're very nice and polite, they sometimes can direct you to where you can find a Zoom link, or you can register. I think for the federal court, at least in Massachusetts, you can register, and I'm sure, you know, they're happy to have, what's it called, spectators or reporters, because it's about understanding the process. So first I'm going to talk about a very simple docket. When I was a reporter back in 2009, I sued under Freedom of Information at one point for a record of an investigation into a fraud, a scientific fraud. And this is basically, by way of introduction to any docket, that's what the top of it looks like, and some essentials of the case. And it started here with docket entry number 1, that's a complaint. You know, I didn't know too much what I was doing at that time because I was pro se, representing myself. I later had representation from 2 lawyers who did not charge me. They were doing it on contingent basis. But when I filed it, this is something I wrote saying, hey, you know, I asked for this record under Freedom of Information. Here's some of the correspondence. It wasn't provided. So that's what you see the complaint. And you see, if you look in the yellow box, that I sued the agency, and I also sued a contractor, UT Battelle. And the first thing that happened in the case a couple months later is that contractor brought motion to dismiss, which I remember not really understanding what was going on. But as I know now, motion to dismiss basically is not something that, if you're interested in the facts, is necessarily going to help as a reporter. This is about, more about the legal viability of a case or a claim, and not so much the factual reliability. So you can be looking at a docket and you can see something be thrown out because it's not legally viable, but there still might be an ethical concern there that you guys might want to write about. On the other hand, some motion to dismiss might be denied, and it turns out that the facts in the complaint later turn out to be not true. So I think if you're writing an article that's calling bulls and strikes and winners and losers, you might be super interested when something is dismissed. If you're more trying to sort of use the court docketing system as sources of information that interests you, that's just something to know, that it can be more technical. Continuing, a year later, the government brought this motion for summary judgment, and this is where facts start to come in. So it's a year later, and it's basically a motion for summary judgment is saying we don't need to go to trial. There's enough facts in the record, or that we can put in the record now, to make a decision without a trial. And so they are supported heavily by facts, and here's some facts. And you know, the factual content here is a number of declarations from officials in the agency, and you know, that was kind of interesting for me to see. The declarations were all different, but the basic message was that we didn't read the record that was requested. So it's not a government record. It originated with a contractor who's been dismissed now. It circulated within the agency, but wasn't read, or didn't circulate and wasn't read. And so it's not really a government record as such. And that was a prevailing argument. They won. They didn't have to provide, the government did not have to provide the record, and that's judgment for the defendants at the end. What I ended up doing though is, upon reading these affidavits and exhibits, I put a story together. I was fortunate that some people involved in the situation I was writing about and had written about and wanted to write about again talked to me after the case was basically closing out. I was able to speak to an author of the record I had first requested. I was able to speak to Whistleblower. I was able to speak to independent scientists who had looked at the situation. They also released a technical document online. And then I had this story about what happened in the investigation. So I think the point here is that there is a difference to understand between information, what you may be interested in or can glean as a reporter from a court docket, and what might prevail. You know, I think I had a reasonable right to that document. The court didn't agree, but ultimately the process still created a degree of transparency, you know, which was a sort of redeeming thing, even though obviously to this day it would have been nice to see it. There wasn't a huge impact of the story at the time, but later, some years later, I saw that it actually got written up by the National Academy. So they were doing this report, Fostering Integrity in Research, and they had a write-up and they actually found that which I didn't even know, the Department of Energy had done a subsequent audit and looked into this problem, which I mean, they've connected it. I have no reason to think it was connected, but I just thought it was interesting that, you know, I feel that as a reporter, people are sometimes looking at what's the metric? Is my metric how many people read the article? Is the metric, you know, I get a Pulitzer Prize? Is the metric that there's follow-on reporting? You know, are you looking for clicks? Are you looking for acclaim, or, you know, just kind of keep your job in the news organization? So those are all the different things. And this was, although it didn't have a big impact at the time, this was a metric I wouldn't have expected. So now let me talk about a complex docket. The man on the left there is Michael Buduniak, and he was a whistleblower of healthcare fraud. Specifically, he alleged that his former company, Biogen, had been paying kickbacks to doctors. And the man on the right is Tom Green, who's my former boss at the Green LLP firm, which is a whistleblower law firm in Boston. And I worked as part of Tom's team. This was a 10-year-long litigation, and I was involved for the last 4 years. And I'm just going to, you know, our team ended up winning kind of a prize when the case closed out. And one of the things that was said in the acknowledgement or the citation for the prize was that this was really a very complex docket with a lot of an enormous number of motions and things to kind of go through. So here's the top of it. Here's the top of the docket, and you see there that it was filed 2012, and it was unsealed. So these types of cases that I've been involved in more recently have to be filed under seal because the government has the opportunity to investigate them before they are unsealed and the defendant is made aware. It was unsealed 2015. So just to calibrate these timeframes, 2012, my daughter was born, okay? 2015, I'm not yet in law school. I was still a reporter. You know, and in the bottom right, you see Department of Justice ultimately press release the outcome in this case, 2022. And my daughter's now, I guess she's she's going into 6th grade. So, you know, I came onto this case. So this is to inform you that sometimes dockets are partially or fully sealed, but many times it's temporary, and to kind of inform you that when something comes out from seal that you might perceive, oh, I don't know if we can write about this because it seems old, but then it's new to everyone else. And this is really, I guess, a court saying, okay, time for this to be more transparently litigated now. So one thing you can do is that I think is helpful is folks can look for scheduling orders. This is maybe about the time or a little before the time I started working on this almost full time. And you see that on the docket, there's some dates entered by the court about when the court will meet back. And it tells you courtroom 9. And often even when a hearing's going to be by Zoom, these weren't, but even when they're by Zoom, it's affiliated to a courtroom or associated to a courtroom where the case is housed. So, you know, there were events here when you could check back, and dates often slide. Sometimes dates like this will be, you know, missed. You might miss something because it's brought forward or brought back, but at least gives you an idea what the, if you like, pace of it is going to be. In these cases, there come a complex litigation. Probably a very important step in the case is after motion to dismiss is passed, discovery opens. We didn't really have discovery in my simple case of freedom of information. That wasn't a thing for that case, but in a complex litigation, the two sides exchange documents and have the ability to interview under oath, namely depose folks from the other side. And there'll often be, you know, I think part of the purpose of this is if you think about sometimes the possibility that people could get into a dispute because they disagree, they have different information available to them. And so things do sometimes settle in discovery because once the lawyers involved get to see each side's information, there's more consensus able to form, unless it's very contentious about, you know, whether there's a claim here, how much it's worth. So there's just some general background. But you know, this case, as in many litigations, discovery opens with a joint motion by both sides for a protective order. It meant basically a confidentiality order where we're going to exchange information confidentially among the parties. You will not see it on the docket, but it's going on. And you know, so now we have a quiz. And I've been reliably informed that this quiz has been entered into the system. So I'm going to run it. Does everyone see a quiz? Can someone tell me if that quiz is, do you guys see a way to answer a quiz? Oh, somebody.
Hi, so I'll go ahead and launch it for you.
Okay, launch it.
So it's just at the bottom. Let's go here.
I think it's been, anyway.
I'm going to relaunch. Here we go.
So basically.
All right, so you should all.
Sorry, Anna, I'm talking over.
So it just popped up on everybody's screens. So the question is, why would the two sides in a litigation want to exchange information confidentially? So you can all just go ahead and put in your choice, and I'll wait for a little bit and then end the poll and share the results.
So I can see, I don't think you guys can see, but I can see how I see people voting. I see that a lot of people are engaged, which is good. If you are still eating your sandwich, I know it's lunchtime, put it down and vote in the quiz. Why would I'll read the question again. I still see people entering votes. Why would the two sides in a litigation want to exchange information confidentially? Think about, you know, in any litigation, could be IP litigation about a patent, could be like this one, a whistleblower bringing a healthcare fraud case. It could be, I'm thinking about complex civil litigation more than in the criminal context. It's slowed down, so I might actually, I still see, okay, there's 50 people who haven't voted, but I'm going to stop it because we have a really big turnout. So I'm ending the poll, share results. Do folks see the results? So most people think that it's to prevent prejudicial publicity. So I think so in my experience, I'm not sure it's true. I think maybe all of the above are true. I think going into trial, prejudicial publicity is obviously a big topic. Way before trial, in discovery, you know, it is important that people can sort of feel comfortable turning those documents over. And I think that there are some documents that it's okay to share in it more confidentially, and others that can become public. And if you have, once you have a confidentiality order, things can go faster because there is a degree of comfort in sharing, knowing that we'll get a second chance to say, hey, this shouldn't be public. Some people might remember the sort of InfoWars Alex Jones situation in, I think it was Connecticut, where he was on the stand and he was being cross-examined by, and this was the guy who was smearing the Sandy Hook bereaved parents and saying that they were hoaxers, and a group of them had sued, and he was being cross-examined. And as I remember it, and I'm totally uninvolved, but as I remember it, he was surprised by certain materials, including his text messages that had been accidentally shared with the other side by one of his lawyers. And of course you say, well, how can something like that possibly happen? But in a complex litigation, there can be thousands or hundreds of thousands of documents, and people are using, I guess, either cloud storage, they might be using some other way. Anna, I see you raising your hand. Maybe I'm going to disregard that because we'll have questions at the end. So things can get accidentally handed over, but if you have an agreement, a confidentiality agreement, it will sometimes include the ability to claw stuff back that was accidentally shared when it shouldn't have been. I assume they either didn't have that or it wasn't activated in the Alex Jones situation, or he wasn't allowed to claw it back. But I think that facilitating the process is a really important aspect of why this happens. And you guys can think of the same thing yourselves. If you're acting as a reporter, you're interviewing someone, if that person believes that every single thing they say is going straight into the newspaper, that may not be the same freely given interview as someone, who wants to sort of chat a bit and make sure that you get the full context and maybe wants to give you something on background. And so, the chance to sort of clarify with you later what a source thinks should become public or not, enables sort of information sharing to start. So I'm not saying you guys are wrong in prejudicial publicity. It is obviously super important, but I'm just, highlighting another aspect as well. So, okay, now I don't know how to get the quiz off my screen. Sorry, do you guys, sorry, I have to go, but I have to get the, how do I make this? Okay, I've got rid of it. Okay, so now we're back to the story of the Biogen docket. It came, the other side didn't move for summary judgment, but our side did. Again, an entry from the docket, a motion for partial summary judgment, meaning that we thought some claims were so strong they didn't need to go to the jury. And that's an example of the motion. There were a bunch of affidavits and exhibits, but I would remind you guys of what I pointed out in on the simple docket. On a complex docket, you see that lawyers and support and oppose support their motions or oppositions, it should say, with affidavits attaching relevant evidence. So this is just an example of one I did. There were colleagues who did much bigger ones than I did, but basically certain exhibits are attached. And for you as reporters, if you're not as interested in the bulls and strikes of or the arguments of the motion, this is where there's some data or some documents, and they might have nothing to do with the actual, even the parties in the case or the claims in the case, but it's information that has made its way through discovery to be agreed upon or allowed by the court to be publicly filed as possibly relevant to deciding some decision. Coming into trial, you'll see a lot of these motions in limine, and these are basically motions about what will the jury be allowed to see. These are some brought by our side. There were others brought by the other side. But again, look for the attachments, look at the exhibits, because this is really the factual content. I'm not saying it's not important what the legal arguments are. I just think that, the data and the underlying facts are important. This case settled on, I guess, a little before the date that you see it on the docket. You see there, docket entry 615. So that's really long, complex litigation. And as I said, 10 years after the case was filed. And, you know, there was a few docket entries later, this one corresponding to an earlier date appeared, which was the transcript of a hearing held on July 6th, 2022. And I believe the case settled very shortly after that, might even have been the next day. This hearing was open to the public, but if you look at the docket, the transcript wasn't released until quite some time later, giving a chance for redactions. So sort of protecting the settlement, which was being made final. But what I think is interesting and here is that if you were watching the court calendar, I don't know if anyone was, I don't think they were, but if people do watch court calendars as a general thing, then you might end up in like a super interesting hearing that no one else is in, or logged onto something that no one else is logged onto. And you might find, oh, wow, that case settles a couple of days later or 2 weeks later. And I was actually there when the final arguments that sort of where everything went down were being aired. So this case was settled for $900 million. That's the amount that in principle is available again to Medicare and Medicaid. Medicare and Medicaid are defrauded by kickbacks because a doctor who's paid a kickback who prescribes and that prescription is billed to Medicare or Medicaid, they've basically caused a false claim to a government healthcare program. So that's our former client got a sizable windfall out of that, and my former firm had some of that. So, but the majority goes back in these whistleblower cases goes back. And there's the Department of Justice announced it. So let me say something about if you're looking at a docket and it's just way too complicated. So you can find friendly lawyers to look at other people's dockets. That's my speculation. I just think there's a lot of folks in the law schools who are really good. There are people, at nonprofits who are available. There are people at law firms who may be happy to comment on other people's cases. If they're not involved, they can. Lawyers who are involved, there are professional rules around what they can say, and we have to be quite careful as lawyers what we can say. But these are the rules that I summarize from the professional rules, and these are kind of, if you like, the parameters for an active litigation. And so I think it may be helpful to understand this, because if you're reporters and you want someone to comment, then don't expect them to comment if you're asking them for prejudicial publicity, to generate prejudicial publicity, which you guys all understand because of how you voted. But, if you have found a public record and you're trying to understand the next step, that's something they might be able to comment on. So now I want to talk about something that didn't make its way onto a docket. This is a Department of Justice press release from, I was in law school when this case was being investigated, and I'm not going to talk about the contents of the investigation, but I'm going to refer to this announcement of the Department of Justice, which was basically that Brigham and Women's Hospital, which is a Harvard teaching hospital, settled research fraud allegations for $10 million. And as with many of these announcements, there's information in there about the nature of the claims. But what I thought was interesting is in this case, there was no associated docket because this was settled actually as a result of a disclosure by the institution. But there was this quite interesting story 5 years later that came out. I think it was 5 years, because this is 2017, 5 years later that came out. I had no contact with these reporters, but they basically followed up on it and kind of went into amazing detail speaking to people. And I know from when I did my book project years ago that sometimes at the time people won't comment, but years later people will open up. and they tracked down quite a bit of funding. Of course, there's always a difference between how much funding in total and how much will end up being in dispute in a fraud case. But this was, some of the numbers were really quite high that they put in the story. And they had this really nice graph. Again, this is Reuters, and basically explaining the impact of some of these cases where this is all, as I understand their chart, this was all dollars going into the general research field, which was adult stem cells, in adults cardiac stem cells. And it was really rising. That's almost exponential off of this group's claims, but also other groups' claims. And then it kind of bubbles down to a lower level. And I guess the question in the story was really like, has this bubble burst to the small size that it should, or is there still kind of inflation as a result of people claiming fraud? And here are some references at the bottom where you can follow up on questions of like public money, or in this case, NIH money. And the article, I think, may have drawn from the Retraction Watch database, which is a database of retracted peer-reviewed research, that can also be useful in terms of relating what's been retracted in there to what was connected to a grant and so on. So that's everything. I don't know what the time is. I don't know if I've only used up half an hour. So we can have a lot of questions. I'm sorry if it should have taken longer, but I can always go back over any of the points. So yeah, Carmen, go ahead.
Last question. And I think you never need to apologize to journalists for not taking up enough time. We do have some questions. For starters, a question is, because lawsuits have dozens or hundreds of exhibits, do you have additional tips for identifying which ones are the most important, or which will have the specific information a journalist is seeking on deadline?
Yeah, that's a good question. So I would look for, I think I indicated this, but motion for summary judgment is the time when some people's claims are going to be decided potentially without trial. So it needs to be a very factually evidenced, a factually sound kind of record before the court to get that ruling. And I would expect more interesting stuff attached to basically, there'll be a motion for summary judgment, there'll be a memo in support of the motion, and then there'll be affidavits which might have exhibits attached. And there's also, as a point of law, if a court is hearing a discovery motion about should more documents be handed over to the other side, sometimes exhibits will be sealed or not be able to be docketed because of the confidentiality order. But there's pretty strong law that when a motion for summary judgment, where someone's claims are being decided that could be relevant to other people with similar claims, that less should be sealed or remain confidential. So therefore, as a general principle, I would expect more interesting stuff to enter the record attached to those motions and also to those oppositions.
Okay, great. Another question is, can you search PACER with the term unsealed, quote unquote? And I guess a related question I'm seeing in the chat is people are wondering if if there's any way for journalists to get free access to PACER.
So access to PACER comes up a lot. I do not know. So first of all, I don't know. And I was going to research it before this presentation because it did occur to me, because PACER is expensive. I know that there's actually been there was a lawsuit recently against the court system for PACER charges, where basically the court system, or whoever was in charge of the court system, was found to be was told that they couldn't sort of use extra money from the PACER charges on things other than administering the system. So I think it's an issue. I think plaintiffs pay a lot in filing fees when they open a case. Some people bringing cases are prisoners, or people who don't have a lot of money to spend. They can generally get their records. But if you're in the intermediate group where you've got some money, but not a lot, where you want to pay by the page, I do think it's a problem. Someone has asked if you can search on PACER for the term unsealed. I don't think so, but the way unsealed, you mean something that was just unsealed? So I think I'm going to rephrase the question. I think someone is asking, can I go to PACER and find out what was just unsealed? So I don't think it allows for that search. I think, first of all, for all court docket systems, you have to know what court you're headed toward, that you're interested in. So if you go to PACER, you can do a query on a party name. I think you can, but it's better if you can identify the district, the federal district that a case is filed in. And then it's not really doing a search over in that functionality. I think you can, however, search by date for cases. Sometimes you can search. So I don't think there is, and I don't think there is a way to quickly find this. And that's actually one of the purposes of having this event, is that there's a lot of information out there in the court system that isn't making its way to where other people, it may be useful to other people, not just journalists, but other people litigating, or people investigating different topics, may not locate it. You have to sort of go and do a lot of kind of brute force search of different locations. Any other question?
Sure.
Oh, somebody asks, are the attached documents available online? It depends on the court. In the federal court system, exhibits are typically, you click the link and you're taken there. You may have to pay a charge. That's what the other person was asking about. In other courts, some county courts, you may see that something was docketed, and you may have to go to the courthouse and ask for help accessing it. And other county courts appear to be online, and other ones you can order for a charge. So somebody asks, sorry, Carmen, do you want to call the questions, or do you want me to access them? Because now I've opened a box, which I guess people can see.
We can see the questions. It's up to you.
So this person, Nick, says, do you have any suggestions for building a practice for just searching or fishing for stories on PACER? I mean, I guess I had some suggestions in this. I think the guiding principle should be, it's not just winners and losers, right? There's information there. It might not be what the case is about. Someone some time ago came up to me and they said they were interested in doing a story about, I think it was about basketball. No, I think it was about football. You can tell that I'm not too good with American sports, but basically it was the one where people are always getting concussions, and football. So it was about, the person was looking at case after case where it was thrown out that the football leagues were not responsible for what was happening. And that was kind of affecting their ability to write about it. And I was just kind of saying, in those cases, I was never a sports journalist, but I know that just because a case is thrown out for legal reasons doesn't mean that there aren't documents in there that are perfectly factually valid filed by either side. So you may still have a story that you want to write, that you can write about, and that is of interest, even if legal claims have not prevailed. Somebody asks, does this relate to all courts or just federal courts? So you're correct that the two dockets I gave examples from were federal courts. However, the rules of civil procedure, which is what kind of what I was talking about, where you get motion to dismiss and you get motion for summary judgment and you get motions in limine, and then you may have a trial or not. Those rules, you know, are applied in other courts of the US and other courts of the states. Somebody asked about international examples. I'm not so familiar with searching, for example, other dockets in other countries. I've done it, but the rules of how their dockets unfold will be different. So I can't answer that. Law is very parochial. It's by geography, and it's by, you know, my license is Massachusetts. I practice in the federal courts here as well, but you're not able to travel in quite the same way as other professions. Lawyers on a case can sign up to receive email alerts when there's a new docket entry. Is there a way for members of the public to do that, or do we need to just regularly check the docket? I think you have to check back. I think the reason that lawyers get notified when there's an entry is partly because that's the electronic system serving the document to them. So if the other side has said something, you might need to respond, or if the court said something, you need to know. I'm not aware of an email alert where you can track a case. I think maybe if you subscribe to a high-end legal database, or if you have, you know, a law library or a really good public library, you could ask if they have a tool like that. But I don't think the court systems will generate those for you. So people are asking about, so somebody asked, what did I mean by the legal viability of the case? So in the example I gave, I had sued the government and sued a contractor of the government under freedom of information. And my claim against the contractor was not viable because they aren't subject to freedom of information, and nothing in that law allows you to sue them. So in order to have a claim against a party, they have to have wronged you in some way, or there has to be some law that allows you to go sue them. So that's what, you know, legal viability is about, is determining, let's assume all your facts are true, everything you say is right. Do you even have a legal claim? And it can be about whether the court has jurisdiction. If this happened abroad and someone's come here and tried to sue about events in another country, you know, the US courts may not have jurisdiction. Can also be that the person wasn't injured, so they shouldn't be allowed to bring a case about this. It's kind of irrelevant to them personally. And it can be that the law or the statute they're suing under doesn't allow for that kind of claim.
Okay, great. Eugenia, is it easier if I ask the questions? It's up to you.
Okay, I'll keep going. You know, somebody says, Marissa Evans says, do I have a tip for figuring out how many lawsuits are happening against a particular company or over a particular issue? So you won't see all of them in PACER most likely, because PACER is only the federal courts, and some cases may be happening in state courts. If you know where the HQ or the state of incorporation of that company is, which are two different things, I would go to those states and search also in state courts there, because that would be an obvious place to sue them. Alternatively, if there's places where a company is transacting business, that would be, you know, a good place to sue them. So if you think someone is, you know, selling to a particular state or community or whatever, there might be lawsuits that would be filed there because that's where they've done the harm. Or you could also, you know, I think you often have to go court by court, but that's the value you're adding when you do that. You know, I think that's how you can say I've done really interesting job with this story because no one else has actually gone court by court and found all of this. So in a way, the fact that it's hard is an opportunity because you're going to have like a unique investigation when you've completed it. somebody asks, how do lawyers organize the events digitally for themselves? So lawyers have various document organization systems, which is an entire topic. There's how they organize the documents that are produced in litigation, and there's how they organize the events in the litigation. Those are often in different systems or folders. And there's all kinds of legal technology. There's the whole topic of AI and the law, which is unfolding. There's the problem of, in the old days, when documents were produced, a lawyer might go to a warehouse outside town and go through, you might have some poor associate who has to be in some warehouse, 14 hours a day, going through boxes, looking for the box with the memo in it, where the chief executive of the company says, I know it's fraud, let's do it anyway, or whatever, hidden document there might be. Now things are electronically produced, and lawyers, face a challenge of organizing it electronically, but there are search functions that are obviously more powerful. So provided stuff can get scans okay. So somebody's asked about experts in litigation, which I think is a really good question. There is a certain amount of expert shopping that sometimes happens. And, I think when you see there's in the US, we have a framework for deciding whether an expert testimony should be admitted. And the standard is whether it's relevant and reliable. So the court will conduct that inquiry, and in case of doubt, they tend to let the testimony go through and the jury decide. But sometimes if there's something really unreliable or irrelevant in the expert report, then so I would just be aware when you see them docketed, whether it's been determined yet if they're relevant and reliable or not. Somebody asked again about e-discovery. Did you, Jenny, mean there is more interesting stuff in motion for summary judgment or motions related to discovery? I think motion for summary judgment. I kind of answered that. Stuff will appear there publicly that may not have been exchangeable, may have been confidential before, or may even have been filed under seal before. And the principle is, if there are other people who need to know why this claim is being thrown out, then that's much more likely for the court to allow it to something sensitive to be publicly docketed. Someone asked about a company that's being sued in many different locations. It's obviously important that people in one location can go read a court docket in another location and find out, hey, here's where the claim was strong or weak. That's partly what transparency of the courts is about. We can't really have precedent, we can't have useful precedent if we can't find out what's happening in other cases. So I would look at motions for summary judgment, because that's where decisions are being made about people's rights or companies' rights, persons' rights. Can everyone bring a key term suit since they're suing on behalf of the government and the government is assumed to have standing? I think anyone can, anybody who, I believe, and either a person or a natural person or a corporate person, either can bring a key term suit. I'm not aware if the government has standing if it's been defrauded. You can't sue if there's no fraud. The reason I'm skipping some of these, just so people aren't offended, is if it looks like you're asking me for legal advice, I'm not going to give legal advice on an event with 250 other people listening. So if that, some of them I'm skipping. Would the relevant and reliable determination appear on the docket? It should. If something's been ruled out, I would think it could also be sometimes going into trial. There's so many decisions to make that the judge will make a decision from the bench, and you'd have to be in the hearing to find out. would the principles be the same in other judiciary systems? Are some more public than others? What would the best example be? I think some are more public than others. I've tried to search for court dockets in other countries without success, such as I'm like, I don't know where I know they're doing stuff, but I can't find their dockets. And it's not always just a language thing. I think, you know, we do have a common law tradition that goes back originally to English common law. In law school, lawyers will sometimes be reading, we've read the occasional case from around the Commonwealth, or, you know, in Australia, or certainly in British common law. I went to law school in America, but, you know, we read cases that were older, that were from the before, if you like, the split of the common law traditions. So, you know, that English common law tradition exists in connected countries that go back to the British system. So I think that if you've taken anything away and internalized anything from today, then you'll have more ability to transfer it to international dockets that are in that tradition. If you go to countries with sort of other types of legal system, like where a lot less is common law and the civil procedure rules are different. In some country, in the US, we have strict rules on admissibility. Like some, as you saw, some evidence will not get in front of the jury because it's not considered something they should be relying on. Other types of court system may allow anything to be brought in. So even in the US, we have administrative dockets, which are in some of the agencies, which allow much more evidence in, I believe, because they're decided by a judge, not a jury, and they're considered, the judge is more able to sort of decide that they're going to disregard something. Any more? Let me see. Can I talk about the difference between stipulations and settlements? So I think a stipulation is when the two sides agree to a fact. So that's what I understand by stipulation. You know, a stipulation is we both agree that, you know, I'm trying to think of something. We both agree that the patient was given a surgery they didn't need, but we disagree about, you know, whether that was careless or not. And so I feel like that would be a stipulation. And then a settlement would be, okay, settlement is someone has a legal claim and they've agreed to drop it in exchange for something, which is usually money. So a settlement means Biogen pays $900 million to the government. In exchange, the government, through the whistleblower, agreed to drop their lawsuit, not go to trial, not have a jury decide how much it should be. So it's the settlement of the claim. What other questions? I think
So scroll down. One we were saying is, what are the ways to find contact details for all the lawyers, parties, and plaintiff investigators?
Oh, so the lawyers' details should be at the top of the docket. I mean, they should have their contact information right there, because every time, and if they sign a filing, like I was telling you, don't read motions, they may not be too interesting, but if you want to know who the lawyers are, you might read them because they probably signed it with their firm details at the bottom.
Okay, great. Another one I'm seeing, this is an interesting question, and I think as someone who was a science reporter and is now a lawyer, Vivian Marks asked, harassment and abusive situations in universities are something I hear a lot as a science reporter, and the interviewees share their experience and confidence, but they invariably tend to worry about taking legal steps, which can be a bruising process. When they ask for advice, I don't know what to advise them. And do you have any advice, I guess, for when people are asking reporters for advice? Do you have any advice on what to tell them?
So I mean, if someone's thinking about if someone's been harmed through a workplace situation, they might have a legal claim. and they can go to a plaintiff side attorney and talk to them about it. Practices like mine, I don't charge people by the hour. I charge them, I take no money up front, and I only charge people if their case results in a settlement, and then my fee will come from out of the settlement. So it's sometimes called no win, no fee. And there are plaintiff side firms, not just mine, that specialize in bringing these kinds of cases. It's called a contingency free arrangement. It's not pro bono, it's not free, but it enables access to the courts for people who don't have money to spend on lawyers right now, but who might have a claim. And I think it's a major reason that we have such an active court system in the US. I personally, coming from a country where there was a barrier to court entry, I think it's a good thing. Some people don't think it's a good thing. They think suing is too easy in America. But I think someone who's being harassed and abused can consult a plaintiff side lawyer, and if they have a good case where it might be worth some money, the lawyer may take it on. It might be very difficult if they don't have a legal claim to get help from a lawyer, because like I said, it's a difference between what's a difficult situation and what's unethical stuff and what's provable, but that's no reason not to try and consult someone. Then in terms of if people ask a reporter for advice, I don't know, it's kind of out of scope, right? I mean, now I'm wondering if we've become as reporters, the friend rather than which does happen, but you want to be the one to ultimately report, and what they may need may be something different. I mean, so yeah, that's pretty difficult for me to answer without knowing exactly what the situation is and what the situation is of the person who's asked this is asking for.
Another question, we're seeing many questions along these lines. Do you have tips for saving money on getting copies of court records? And Denise Marie Ordway, our managing editor here at the Journalist Resource, said in her experience, court copies are much more expensive on a per page basis than copies of records from, say, a city government or a state agency.
So basically, if I don't have a good answer to how to save money, a small firm like mine is also spending money on court record searches, and it also bothers me. So I sympathize greatly with it, and I agree with the sentiment that it should be easier to do these searches and not have to spend money. And I don't have a solution other than I think that obviously the lawyers involved get a copy. So if a lawyer involved is amenable to it, they may share you their copy. And if it's a very long filing, they may share it, but they may not. They may just not want to deal with the press. So if it's a nonprofit that's suing, or someone who's doing it for public impact, I would expect them to be, they may even have it on their website, but I would expect them to be happy to share. And even, you can even ask them, well, what did the others, give me the other side's opposition to that? They have it. They may do that too. But if it's between two private parties, or you've got two companies suing each other, I don't know if their lawyers are going to be particularly helpful. So,
okay, and we have 1 minute left.
Okay.
Stay for a few minutes if there are additional questions. One question I saw that I think you missed were, do you have advice for when it's sufficient just to go to PACER, and when you advise actually going to the courthouse?
So this depends on whether the hearings are. So PACER contains all the court filings that are available online. If there's a hearing, you need to go to the calendar and find out how the hearing is being held, and either register if it's going to be on Zoom, or get the name of the courtroom, and then you'll go to the courtroom to attend in person, and you'll learn on the calendar where it's going to be. Now, if you want to do a state case, the rules are going to be different, but there'll be something like the calendar for the federal court. There'll be I think in Massachusetts, it's called daily list. It's a list of all the hearings coming up in Massachusetts. And in that case, you may need to inquire with the clerk, what's the Zoom link? I believe it should say whether it's a video hearing or phone hearing, or sometimes it's a phone. I've been on phone hearings where you get on the phone and then someone announces and says, you know, the judge is joining the call now, and then the court's in session. Then they hop off the call and the court's out of session. So, you know, there's different ways, but unless it's a closed hearing, you should be able to find out from the clerk how you can sign on to it, or how you can get the video, the conference call dial in, or however it's happening. Somebody, this lady, Susan Beachy, asked me, sometimes the last document in a case is labeled stipulation. Is that like, an agreement of what's happening? Or like I said, I think of a stipulation as agreement on some facts. And I think of it as different to settlement, a payment of money, an agreement to drop a claim. But I have to see this. Is the information privileged because it was filed in court? I think this person may be asking for legal advice. I'm not giving legal advice, but I will say that I think you're asking, this is this Dan Calla question. I think you're asking, if I find something in a court record and I report from there and it's super negative about someone, am I exposing myself to risk in what I'm saying? And I would say, you know, be careful as to whether it's a factual filing or whether it's an argument filing. And that's what I tried to distinguish today. And look for an affidavit where somebody sort of gives out the authenticity, warrants the authenticity, and just try to be accurate. And like I said, if you don't understand it, I believe there are friendly lawyers who will tell you what, you know, something about that. I don't think they necessarily give you advice, but can tell you this thing is an affidavit, someone sworn on penalty and perjury. Then when you report it, you're not going to say it as fact, but you will say this has said in an affidavit that carries more weight. Is there any organized movement? So somebody's asking about organized movements to reduce exorbitant fees. And like I said, I saw that a lawsuit was settled recently involving PACER and the federal court system. I think I saw a discussion about it on LinkedIn. So I do think there are entities and organizations working on bringing the costs down. Any tips for finding the courtroom numbers? So it should be in a scheduling order, and usually they stay in the same courtroom for a while, or even the whole case. Or on the court calendar, it will tell you, you know, courtroom 9, this thing, courtroom 10, this thing. So you'll want the calendar and look for the courtroom number, even if it's a Zoom hearing, because there's like a physical place where the clerk is for that courtroom, and that's the person who may be able to help, or the clerk of court office may be able to help with getting you the information. Dan Keller says he hasn't been sued yet, no pending action. I mean, we're getting to the.
Yeah, I think we're 5 minutes past time.
Okay.
Mindful of your time, Jenny. Thank you so much. That this was wonderful. And I'm realizing that there's a need for. I encourage everybody to visit journalistresource.org for more tip sheets. But I'm realizing there's a need for a tip sheet and some lobbying on figuring out how to make it cheaper for journalists to get access.
Yeah, I think so too. I mean, let me just stop Stop share. Yeah, I agree with that. That a lot of people were worried about the cost, and this is something that, you know, a law library could try and help with. There is a very good law library in Boston called the Social Law Library. I don't know if you can join as a reporter, but you can get access to a lot of powerful search tools there. Someone's also posted here about Court Listener. I don't use it, but says that it has alerts. So maybe I was wrong that there's no way to get an update on a docket. I don't know how, I haven't used that.
We'll be sharing the video on the Shorenstein Center website as well as on journalistresource.org. And we will also share key tips from this webinar, and we'll do a little extra digging to see if there are links to things like Court Listener that you may know about. But this was fantastic, and hopefully we can do it again soon. Thank you.
Thank you for inviting me, and thanks everybody for tuning in. Bye.